All right. So again, welcome to the November 2025 LIBOR legal update. My name is Patrick Fife. I'm LIBOR's general counsel. And as I start every class that I teach, I always like to remind everybody to um, use LIBOR's resources to stay on top of changes in the law. There are so many changes. I'm going to go over a lot of new material today, things that I didn't cover last month or in prior months. And so if you miss this class, how do you stay on top of all that? Well, we give you a lot of free resources here at LIBOR to help you with that. The Thursday email always has a weekly legal tip in it, a lot of other information. Make sure you get that, you sign up for it, you don't have it in your junk folder. Check out our webinars. I want to highlight one that we did yesterday on lawful source of income from the New York City FEPS voucher, statewide FEPS voucher program. I'll talk a little bit about that later. But it's something I think everyone who handles rentals should be aware of. It's a great program, and I'll talk more about that later. But also, whether they're events, our broker resources, just go to the website, lirealtor.com. Ton of information there for you, and helps you stay on top of the changes as they happen. I just, I know there's a lot of other places you can go. But in terms of getting the most reliable information out there, I think we are the source that you can rely on for that information. So check out again the website, lirealtor.com, the legal tips, documents on demand, dispute resolution center. So that's if you've got an ethics complaint you want to file, an arbitration, or also our ombudsman service, which is really just a free dispute resolution service. It's a more informal process where we can get a third party realtor involved to resolve miscommunications that you might have with another realtor. It's a great benefit that you should really consider taking advantage of. Prevents issues from becoming legal problems. That's the simplest way I can describe it. So you can resolve what could be a big headache, a big legal expense, simply, easily, and for free. Last benefit. Please remember, we have our own legal support center. You still have access to the NYSAR legal helpline, but in addition, LIBOR has set up a legal support center earlier this year. It's available Monday through Friday, 9 to 5. And a very qualified attorney can provide you information on different real estate matters and questions. The numbers there, it's our LIBOR number, 631-661-4800, and it's extension 335. So I like to begin the legal update with just some questions that have come in this month to the Legal Support Center. I guess, what are you asking about, and what are your colleagues asking about? Well, a couple things that have come in recently. This one came in two or three times this month. I have covered this in prior months, and the question is, can you co-list a property with another listing broker? So have co-exclusive listing. The answer is yes, you can. And it can certainly save a lot of aggravation in cases where you have joint owners who disagree on who to hire. Matrimonial divorce cases, right? You sometimes have two spouses who want to hire different people. They don't want to hire the same person. Well, you can hire two listing brokers in that situation. Our MLS rules at One Key allow for that. You can submit a co-listing agreement and identifies the one broker has to be identified or designated as the listing input agent. So that broker would be responsible for maintaining the listing. You can't have two people maintaining the listing in the database. So the thing just to make sure is co-exclusive listings, they can't be entered twice. There's one entry, one listing. It's maintained. The agreement would have one broker who would maintain it. So just be aware that an owner can't direct two co-exclusive agents to have two separate listings. It goes in as one listing, and the co-exclusive listing agreement has to identify who the listing input agent would be. As far as compensation, that's up to whatever you and the seller agree to with, or sellers agree to with the brokers. But check out MLS Rule 317 for more information on that. We've also done a legal tip on that as well. Another question, clear cooperation, which is a policy that does remain in effect, requires any property, residential property that's publicly marketed to be entered into the MLS within 1 business day. It does not apply to commercial properties. This question has come up a lot. Does clear cooperation apply to commercial properties? The answer is no. It's all residential properties, meaning 1 to 4 family homes, cooperative apartments, condos, homeowners associations, townhouses. It also includes rentals. It's another question that comes up. So clear cooperation policy does apply to rentals. So if you get a new rental listing and you're going to publicly market it, which would include anything, flyers, for sale signs, social media ads, you must then put it into the MLS within 1 business day. Also includes vacant land. So it's really any residential property. Here's a question also that came in this month. It was an agent who was changing brokerages. Agent said, well, I want to finish up the deal. I have a deal that's kind of reaching conclusion. I want to finish it up under my old broker. My old broker agrees. They're okay with me kind of finishing it up. Well, you can't do that. Why? Well, in New York, a real estate salesperson can't do work for a broker other than the one they're licensed for. Your broker holds your license. The concept in New York, and I think just about every other state, is the broker owns the listing, and the only individuals that can service that listing for that broker are that broker's associated licensees. So, in that instance, the salesperson can, I don't even really know what they meant by finishing up, but certainly provide real estate licensed activity, services to a client. It's not your client anymore. The client belongs to that broker, and that broker or that broker's associated licensees would need to continue to service that client. And just remember, if an agent leaves an office, they don't take those listings with them. Those listings belong to the broker. Certainly, the broker can release the listings to the new broker for that agent who's departing. But everything is owned by the broker. The listing broker owns the listing, not the agent. And you can only do work under the broker who holds your license. We've gotten a lot of questions lately about, I think, things that come from the NAR settlement. I'm surprised this question comes up, but it does, and I just want to go over it. So, is a seller required to offer compensation to buyer's agents? We know from the settlement that compensation is not allowed in the MLS. Offers of compensation are not permitted on the MLS. Sellers and listing brokers can still offer compensation. They are allowed to under the settlement, but that doesn't mean they are required to. And that's a basic principle of the NAR settlement. Remember, compensation is always negotiable. So a seller is not required to offer compensation to buyer's agents. I know that calls have come into the legal support center from buyer's agents saying, well, the seller won't tell me, or the listing broker won't tell me what the seller's offering. If the seller doesn't want to offer anything up front, they don't need to. The listing broker's acting in the best interest of the seller. They're going to tell you whatever the seller wants to tell you. They have to follow the seller's instructions. A seller does not have to affirmatively offer or agree to offer compensation or even accept an offer from a buyer's agent that includes compensation. Certainly, buyer's agents should, if their buyer wants to, include compensation as part of the offer, and then it's up for the seller to weigh whether they want to accept that offer or not. I sort of make a simple analogy here. Compensation, it's just a term of the deal. It's a negotiable term of the deal. It's no different than price. The seller is not obligated to accept less than they're asking, and the buyer is not obligated to offer only what the seller is seeking. It's a negotiable term. It really comes down to the net at this point. Another question that comes up since the NAR settlement, when do I need a written buyer agreement and what needs to be in it? This is an essential term of the NAR settlement. It's been a requirement under our MLS rules since August of 2024. But it's prior to touring a home with a buyer. A participant in the MLS or its agents have to have a written agreement with that buyer. And that written agreement has to disclose certain things. And if you don't have it, and it's discovered whether a buyer makes a complaint that you have not, you can be fined under the MLS rules. There can be significant consequences for not having that written agreement prior to touring a home. And that agreement has to disclose the amount or rate of compensation that buyer broker is going to receive. That compensation needs to be objectively ascertainable, not open-ended. So you can't have an agreement with a buyer that says, well, I guess you could say I'm not getting paid anything, and then you don't. That's it. You wouldn't be able to get paid anything. So it can't say I'll get whatever the seller's going to pay me. It has to be a fixed, ascertainable amount. You also have to indicate that you cannot receive compensation from any other source that exceeds what you agreed to with the buyer. So, really the settlement is setting the rate that the buyer or amount that the buyer agent receives from the buyer. That amount, the seller can agree to pay that. You can shift that responsibility in the offer and the purchase agreement, but ultimately the buyer is the one that has the say as to what the maximum amount that their agent would get paid. And your agreement also has to include that conspicuous statement. And any agreement you have with any client should always say and needs to say that compensation or commissions are fully negotiable and not set by law. Another question we've seemingly get a lot of, and I've covered this one in past legal updates, is broker agency, and who does a broker's agent work for? I encourage all of you, and if you're a broker, I encourage all of you to send your agents or tell your agents they should take an agency course. I know it's required every 2.5 years. Every 2 years, you're required to take agency, but I think I would take extra agency courses so that you really understand the fundamentals of agency. But a broker's agent is someone from a different firm, a licensee from a different firm who's engaged by either the buyer's broker or the seller's broker, the listing broker, to assist with the transaction. So think of it as, I am a listing broker. I have a listing, and I'm going to engage a licensee from outside my brokerage to assist me with selling the property. That is what a broker's agent is. They have no direct relationship with the buyer or the seller. They serve and work for and take instructions from another broker. And that broker who hires the broker's agent or who extends agency to another licensee from outside their firm, they're agreeing to be vicariously liable. So if I hire Therese to be my broker's agent or extend anything she does or says to anybody, I am agreeing as that broker to be responsible for what she did. That's what a broker's agent is. And so that broker's agency, it comes about, it's an agreement between basically a broker and a licensee from another firm. It really has nothing to do with the buyer or seller. And I also remind everyone, you cannot designate yourself a broker's agent, right? You need the permission and consent of another broker. It's basically another broker. In the example I gave, it's me saying to Therese, hey, Therese, I want you to be my broker's agent. Therese can't just walk outside tomorrow and say, I'm going to work as a broker's agent today for XYZ brokerage, Patrick's brokerage, and every other brokerage. It doesn't work that way. You have to get the consent of the listing broker or the buyer's broker to work as a broker's agent. So Wendy, I see a question. I think she was looking for an example of when a listing agent might want to hire a broker's agent. Um, I'll give you an example. Let's just say I'm a very small firm. Maybe I'm an independent. I'm just a broker who works by myself. I have no agents, and I have a listing. Or even if I have a buyer, right, and I'm scheduled to take that buyer out tomorrow, well, not tomorrow. Tomorrow's Thanksgiving, but let's say on Saturday, and something comes up. I have a family emergency. I can't take that buyer out, and I want someone else to go take that buyer out on my behalf. I might ask someone from another brokerage. Maybe it's someone I trust, a friend, whatever. I want you to be my broker's agent to go show that property. That's an example. I mean, there's a lot of different examples you can certainly come up with. But again, it's really that broker saying to another licensee who's not in their firm, I want you to be my broker's agent. Certainly, if you're in a firm that has multiple licensees, if I ask if my example, again, sorry to keep picking on Therese, but if Therese works in my office and she's a salesperson, she's not, and I ask her to come and hold the open house on Saturday for me, and she's already in my office. She's not a broker's agent, right? She's just an extension of me as the listing broker. So she would be a basically a seller's agent in terms of any kind of disclosure to anybody that walks in, but she works for my firm. A broker's agent is always going to work for a different firm. So hopefully that gives you, a good example of what. Somebody asked, well, how does a broker's agent get compensated? Well, you would have to get an agreement from that broker to say what is the compensation in that instance. It really depends. I think the confusion that's still out there is, we used to have a broker's agent field in the MLS where somebody might offer out compensation to cooperating brokers as a broker's agent. That in effect was an invitation to serve as a broker's agent. We don't have that anymore. So there's no longer, there's no compensation in the MLS. So there is no unilateral invitation by a listing broker for other brokers to serve as brokers agents. I wouldn't say brokers agency is dead, but it's certainly something I think that since the NAR settlement is more limited. And again, I just want to reiterate that you need the permission of the broker who's designating that agency before you can work as a broker's agent. So hopefully that gives you a little bit of more background on what a broker's agent is. But I encourage all of you to take an agency course, especially a new agency course. Put it on your to-do list for 2026. I think it's a really important thing for you to understand and be able to obviously explain to your clients. All right, so we're going to move forward. I do want to just let everybody know that cold calling restrictions in New York unfortunately remain in effect. You've probably heard me say there is a law in New York that during a declared state of emergency, no telemarketers are permitted to make cold calls offering goods or services to the public. It's hard to believe, but we're under 3 states of emergency right now in New York, 3 separate ones. And they may be extended. They get, without much fanfare, the governor just signs a further executive order extending these. And as a result, there is a law in New York that says during any declared state of emergency, no telemarketer can make an unsolicited phone call to members of the public. Any other kind of marketing is allowed, but technically in New York State right now, cold calls are not allowed. I have the emergencies up on the screen. I agree, this is not a good law. Unfortunately, it's not one that anyone has been successful at getting changed. The states of emergency right now relate to Supplemental Nutrition Assistance Program, SNAP, another one related to federal actions related to vaccine mandates and also public order at correctional facilities. So as a result, because of these, we cannot make cold calls, right? So you can, I promise you, LIBOR and NYSAR will give you an update when these states of emergency have officially expired or no longer renewed. But I just want to give you a warning. Department of State has held or had attempted to hold certain brokerages liable for calls made by salespersons that violated the cold call restriction. And the fines can be up to $20,000 per call. So it's not something that, that you should take lightly. It is something that can and has been policed by Department of State. And there is one reported instance where Department of State is seeking to hold licensees collectively liable for over $13 million in allegedly improper cold calls. The allegations in that particular case involve not only cold calling in violation of state of emergencies, but not following other cold call laws. I don't want to go into this in too much detail because right now cold calls are not allowed. But if they were allowed, there's another law that went into effect earlier this year that put a whole host of requirements on anyone making a cold call. You now have to state your name, identify your company, the purpose of your call, identify whether the call is being recorded, and give the recipient the option to be added to your company's internal do not call list. And you have to do that within the first 30 seconds. So there were also allegations in that case that the callers did not do that. So it's just really important that you be aware of this. And I see a lot of comments about this. I know somebody said I get calls all the time. I got one like 30 seconds before this class started, not from a real estate licensee. And I get, look, you could report those people. I will say the difference that you or we have here in this group is you all hold a license from New York State. The person selling solar panels, the person selling car warranties, whatever loan modifications may or may not have a license. It's just you need to be careful. Door knocking, any other kind of marketing is fine. It's unsolicited telephone calls and text messages. So really just make sure, there's a question about is door knocking allowed? Yes, door knocking is fine, provided it is not prohibited by any local law. There are some local municipalities that you need a peddler's license for. This is a state law, though, and it applies to unsolicited telephone calls and text messaging. Just remember, when cold calls are allowed, we also have the National Do Not Call Registry. So I encourage all brokers, make sure that your salespersons, your associate real estate brokers are aware of the restrictions. And once calls are allowed, you need to really exercise caution. Make sure you're doing it the right way. You're not calling anyone on the National Do Not Call list. Very important. Brokerages should have guidelines on when it is, when cold call is and isn't permitted. And I would also suggest that they provide scripts to anybody in their office. No, oh, I'm sorry. This question, this meant to go this before cold calling. This was another question that's come up. So I apologize. This slide got put in the wrong order here. The FAIR Act. I'm not going to do an entire presentation on the FAIR Act. I've covered it in the past couple of legal updates. So if you have questions about the FAIR Act, take a look at the past couple of months. But we are still getting a lot of calls about this. What is the FAIR Act? It is a New York City law. It's the Fairness in Apartment Rental Expenses Act. And it prohibits New York City residential landlords from passing the fee of their brokers on to prospective tenants. So it prohibits tenants paying any fee to a landlord's broker, period, any fee whatsoever. It applies only in New York City. I can't tell you how many times we've got this question, even in the last 2, 3 months. It applies only in New York City to residential rentals. So if the property is located in New York City and it's residential, FAIR Act applies. So if you handle rentals in New York City, if your office handles rentals in New York City, please take a look at the resources on our website regarding the FAIR Act. Make sure you're familiar with it. Long Island, yes, well, at least Queens. Remember, Queens is part of New York City. So the 5 boroughs are all part of New York City. Nassau and Suffolk counties are not covered by this law. It is still permissible in Nassau County and Suffolk County for the landlord to have asked for the tenant to pay their broker's fee. Queens and any of the 5 boroughs, the answer is no. All right. So I want to just now move on to something that's new. It just came out in the last 2 weeks. and goes into effect in the beginning of the year. We just have some changes to the Code of Ethics that you should all be aware of. They were approved by the National Association of Realtors at this month's annual meeting. Um, they're more aimed at they go into effect January 1st of next year, 2026, and they're aimed at kind of furthering the NAR settlement. So the first thing was Article 7 was amended, and this was changed just to make clear that if you're getting compensation from more than one party, they want to clarify that the disclosure and approval requirements only pertain to your client. So you need your client's approval and you need to disclose to your client that you are receiving funds from more than, if you are receiving funds from more than one party. The reason this change was made is just to make clear that a listing broker um, does not have the right to see or approve a buyer broker's agreement with their buyer. I know there's been a lot of questions and calls, even to our legal support center, saying, does the listing broker have the right before they agree or the seller agrees to compensate the buyer's agent? They're demanding a copy of the buyer broker agreement that the buyer's agent has. They have no right to see that agreement. So it's just the same as a buyer's agent can't ask. Well, they could ask, but there's no obligation that a listing broker provide the listing agreement that they have with their seller. They're two independent agreements. There's no obligation for a buyer broker to disclose the content of their buyer representation agreement with the seller or the listing broker, period. Another change, just this one is standard of practice 3.4 was deleted. Not going to go into this in too detail. Why? Because it's not applicable in New York. The Department of State already felt and has ruled that this standard was not applicable in New York. The requirement was to disclose variable rate commissions to other parties to the transaction. New York State had already long ago felt that this standard of practice was inappropriate because they felt it was disclosing confidential information that the seller had with their listing broker to other parties, and it wasn't something they were entitled to have. So that practice is now standard practice deleted nationwide. And the last thing I just want to let everybody know, and this is just more to I would say not really a big change, but this is standard of practice 17.4 was updated, and that has to do with non-contractual disputes that are subject to mandatory arbitration. And it just clarifies that, and it's really to comply with the settlement agreement, that any compensation awarded in an arbitration to a buyer's agent can't exceed the amount that was within the terms of that buyer representation agreement. So let's just say there is an arbitration where a cooperating broker is seeking a certain amount. They can't ask for more than what their buyer had authorized them to receive in that buyer representation agreement. Remember, I said that's a term that needs to be in every buyer representation agreement. Now it's also really, I would say, codified in the Code of Ethics to make sure that, in every instance where a buyer's agent may be able to recover in an arbitration, that they're not going to be allowed to recover anything more than what they agreed to with their buyer in their buyer representation agreement. So that was the update in Standard of Practice 17-4. There were some other possible amendments that were kicked around, voted upon, but that did not pass. So these are really the only three changes that will be in effect as of January 1st next year to your Code of Ethics. I want to talk a little bit now about unrepresented buyers. This is a new topic. I haven't covered this one before, but we've gotten some calls to the Legal Support Center about how to handle unrepresented buyers. I think some more questions have come out about how to handle unrepresented buyers in light of the NAR settlement. I think there's been some confusion that, oh, well, following the settlement, buyers can no longer be unrepresented. That is not the case. So I want to make sure everybody's on the same page and just provide some kind of an overview of how unrepresented buyers should be handled. The first concept I want to make clear is buyers have the absolute right to remain unrepresented. They should, the NAR settlement does not require an unrepresented buyer who contacts the listing brokerage directly to have a written buyer agreement or to enter into an agreement with the listing broker. Buyers have the right to remain unrepresented, and they do not need to sign any agreement with the listing broker in any way. They certainly can remain unrepresented. Um, Listing brokers can't prevent unrepresented buyers from touring a home at an open house or otherwise. And they should never mislead any unrepresented buyer to think that they have to sign a written buyer agreement with that listing brokerage. They are free to go it on their own. So that's first. I just want to make sure that everybody understands that. Second, there are disclosure requirements, though, that you need to abide by if you are dealing with an unrepresented buyer. So you would first want to explain, obviously, that you represent the seller. I do not, right? Look, you don't have any representation. You don't want any representation. Therefore, I'm letting you know that I work for the seller and I am not representing you. You should certainly advise the buyer. They can seek their own representation and legal counsel, and you want to, upon first substantive contact, so if they start talking to you about the terms of the deal, making an offer, you need to provide them the agency disclosure form stating that you work for and represent the seller. This applies, there's a question from Veronica. This applies to everything: open houses, private showings. Buyers have the right to remain unrepresented. And if they want to be unrepresented, you provide them the agency disclosure form and make very clear that you are working for the seller and in the seller's best interests. You're also going to provide them the housing and anti-discrimination disclosure form. What are you permitted in terms of your scope of dealing with them and your responsibilities? So you can write up an offer as directed by the buyer, but you can't give strategic advice to the buyer. Again, you're there to represent the seller's best interest. You're only acting in the seller's best interest. You're not there to help the buyer negotiate a lower price. You are there to represent the seller and what's best for the seller. You can share information such as comparative market analysis to justify the listing price, but you shouldn't provide any information to support the buyer's negotiation. You are there to negotiate only on behalf of the seller and provide the seller the buyer's offer that the buyer has come up with, and nothing that you do should be in the buyer's best interest. Certain conduct during the transaction. So if there are post-contract negotiations, repairs, contingencies from the buyer's side, those should be handled by the buyer's attorney, right? You can accompany the buyer during an inspection and walkthrough, but you shouldn't be handling questions on their behalf. You shouldn't be working for them. If they have questions, you should be directing them to their attorney. You should not be answering them for the buyer. You certainly have an obligation to disclose material defects. You can't make any misrepresentations, but you are not there to work for the buyer. If you're dealing with the buyer, your duties are honesty, right? Good faith. You're going to disclose all material facts affecting the property. But that's it. You're not there to provide them more information. You're certainly never going to share confidential seller information. You don't want to share the motivation of the seller. Hey, my seller's really looking to sell this property because they're going through a divorce. That is not something you should be disclosing unless the seller tells you they want you to. You need the seller's consent to make any kind of disclosure. You shouldn't be recommending inspectors, attorneys, lenders. Buyers need to conduct their own research and consult with their own attorney, period. Compensation. So if the seller agrees in the listing agreement, You can receive an additional fee from the seller if you procure an unrepresented buyer, but you want to make sure that that is made clear in your listing agreement. Some listing agreements, including LIBOR's exclusive right to sell agreement, do give the option for the seller if they agree to provide additional listing broker compensation where a buyer is unrepresented. So again, you should deal with that I'll say eventuality up front with your seller. When you take the listing, explain, hey, there may be a buyer that comes through that is unrepresented. It may involve additional work on my part. It's work I'm doing for you, but I may have to write up an offer. I may have to accompany them at an inspection. There are certain things I may have to do. I'm not working for them, but there are certain work, and in that case, my additional fee would be whatever you've agreed upon with the seller. That is permissible, but you want to agree with your seller upfront on that eventuality. Dual agency. So you can only charge the buyer for their, if you're going to charge the buyer for that work, you at that point need the informed written consent and you to operate as a dual agency, a dual agent, or a dual agent with designated sales agent. And you have to disclose that compensation then to both parties. So this is what dual agency would be. If you are I'll back up the prior slide where I said that's not dual agency. If you are working just with the buyer as a customer and in those past slides, only providing the services that I explained, and don't go beyond anything. You're not operating as a dual agent, but you can't charge the buyer for that. If you're going to be charging the buyer for the transaction, at that point, you need the informed written consent of both parties. You would be operating as a dual agent in that instance. You need informed written consent. That means you need to not only have the agency disclosure form signed and acknowledged by both parties that you are operating as a dual agent, but you want to provide them all of the information on what that means. We have on our documents on demand a disclosure form that goes through, and you should walk through both parties what that means, including that you would not have an undivided duty of loyalty to both parties. That needs to be fully explained to the parties before you can work as a dual agent. So a buyer should not sign a written compensation agreement with the listing broker unless there is dual agent and dual agencies involved, and that you've made all of those disclosures. So, just make sure you're aware of this, that again, buyers can be unrepresented. There are very limited services that you can provide as the listing broker to the buyer in those circumstances, and you would not be receiving any compensation from the buyer. But you could receive compensation from the seller for providing that extra kind of service. But you want to make sure that that's mapped out in your listing agreement before you take the listing. If there's any other questions about this, I'm happy to answer them at the end. And we've also done a much more detailed legal tip on this earlier this month for you to take a look at. Next topic I like to cover in every class is just some advertising best practices. Make sure that you just, after this class, take a look at the two handouts that I gave you regarding advertising. They come from the Department of State. It's just a checklist, one of them. And the checklist, it's the same checklist Department of State uses if they were to ever look at your advertising. So it's really important that what you do, I think I'd say every 6 months, but certainly every year, and now's a good time to do it, either end of year, beginning of next year, go through your advertising. Make sure you're following the Department of State guidance on everything. Is your license type identified correctly? Are you using your licensed name? No nicknames? Do you disclose the name of your broker? Do you disclose the broker's physical office address or phone number? It's really simple things for you to do. And if you don't do them, you're opening yourself up to fines from the Department of State if Department of State ever reviews your advertising. And brokers in particular, you can be fined for your agent's unlawful advertising. The Department of State the advertisements are advertisements of the broker. So brokers are responsible for their agents' advertising. Another thing I want to make very clear, because I continue to see just in general an increase in the number of teams that are out there and advertising by teams. I just want everybody to be clear that team advertisements are an extension of the brokerage. So team advertisements must include real estate brokerage's name. There are requirements for what needs to be in a team name. They either need to include the full license name of the broker, the associate real estate broker, or the salespersons who are part of the team. Or if the name's not included, the team name must be immediately followed by at and the full name of the brokerage. It's very clear. You have to use the word team. Any other kind of term is prohibited. And the use of a name of a non-licensed individual in a team is prohibited. And again, team advertising is an extension of the brokerage, and brokers are responsible for team activity. I Teams are not their own entity. I hope everyone understands that. Whether you're part of a team or you're looking to form a new team, teams are really only recognized under New York state law as an advertising vehicle. They are not a separate legal entity. So a team cannot represent that the team has listings. Only a broker can sign listings. The Department of State can discipline team members and their brokers who allow teams to advertise or represent that the team itself has listings. Teams cannot enter into agreements with consumers. They can't have their team name on documents that are given to consumers or collect commissions directly from anybody other than their broker. So a team cannot charge a client or consumer directly for services that are being provided. Teams are simply an advertising extension of their brokerage. Teams can have agreements internally with their brokerage, but they have to follow all these requirements when it comes to advertising and dealing with members of the public. And if they don't, not only can the team members be disciplined, but the broker certainly can as well. Teams also, they cannot issue independent contractor agreements to their team members. The independent contractor agreements need to come through the brokerage. The brokerage is the one that has the agency or independent contractor relationship with the individual licensees that work under the brokerage. Lastly, really just a repetition there. Independent contract agreements, they're between the broker and the associated licensees. We've got a lot more information at lirealtor.com on teams. So, if it's something that you're involved in on a team, you're a team leader, you're a broker who has teams, just take a look because I do see a big increase in the number of teams that are out there, which is fine, but you just want to make sure that you're doing it the right way and not subjecting yourself or your brokerage to liability. I see a question popped up going back to state of emergencies. Is there a website where we can see where these emergencies are or will be over? NYSAR does have I could probably put a link in the chat later afterwards. They do have a web page. If you just Google NYSAR, NYSAR state of emergencies, they do have a page that they do update regularly. I can also tell you that once we are no longer under any states of emergency, I'm sure NYSAR and LIBOR will both do a flash update. We've really been under a perpetual state of emergency or emergencies for upwards of, it's got to be almost 2 or 3 years. There was a brief pause during, I guess, after COVID, maybe about a month or two, where I think there was no state of emergency, but we've really been under one. The practice is the governor pretty much extends these states of emergency every 30 days or so. And it's just done by executive order. But NYSAR and has been tracking them and does provide regular updates. So if you don't want to go to the website regularly, my guidance would be at this point, No news means that the states of emergency have continued, and you'll be advised as soon as all the states of emergency are lifted, or the law changes. I mean, my hope is, maybe the legislature will make a change to the law that clarifies maybe only certain states of emergencies are covered. But it's been very difficult to get any members of the legislature to support a law that would allow for more cold calls. That's really the issue. I don't think many of our state legislators want to be tied to a law that effectively allows more cold calls to happen. So hopefully we have some changes, but status quo until you hear otherwise. Another law, I did cover this last month, so I'm going to speed through this a little because there's another topic I would like to get to at the end. But I just want to let you know this is not a new law, but it is something that everybody should know. It's the Consumer Review Fairness Act. And what is that? It's a federal law, and it protects consumers' rights to share honest opinions about businesses, including real estate professionals, without the fear of retaliation. So, really anything. So it protects a consumer's right to say, hey, this real estate agent didn't do a good job, or I feel that they were not representing my best interest, and they want to do that and they have the right to do that without the fear of retaliation. And this would include the ability to share opinions, honest opinions, on social media. So, what are the key provisions? The thing you have to look out for is you cannot have any form agreements or contracts, so like a listing agreement, a buyer representation agreement, that would restrict or penalize reviews, that would transfer intellectual property, meaning that the person signing the agreement, any review I post, I give you the intellectual property rights or the right to change it. You can't threaten legal action over negative reviews. So if you have any clauses like this in your form agreements, they're illegal. You cannot, and I've seen them, not necessarily from any of our members. I've seen them in other types of agreements, other types of consumer agreements that say, you agree not to post any negative reviews or any reviews about the services that we provide. And if you do, you're going to be penalized or have to pay money. Anything like that is not permitted by federal law. Um, so what do you want to do? Check all your form agreements, especially if you're a broker. Make sure that all of your agreements don't have these clauses. Consult with your legal counsel to if you've got any questions. I also recommend you want to avoid any kind of non-disparagement clauses, any clauses that try to prevent people from posting negative reviews. That's a problematic. The best thing to do is, and I've seen many of our members do this. Look, you're going to have people that sometimes are unhappy or do say things that are false. The law does not prevent you from addressing negative feedback. So whether it's posting responsive comments that explain the situation, that refute whatever negative feedback you got, and it certainly doesn't give the right to somebody speak falsely about you. So if there is a consumer that does make false statements about you, you certainly have the right to take legal action against them. But this law really, it just prohibits you from putting any restraints in your listing agreements, your buyer broker agreements, that would prevent people from posting reviews about you. So just make sure that you're following that. And I say, why is it important? Well, Federal Trade Commission, one, they could seek civil penalties against you over $50,000 per violation. The other important part is the FTC can seek to void the contract provision or the contract altogether. So if you have like one of these agreements that has a legal provision, it could cause you to lose the agreed upon compensation. So if you have a listing agreement that says you, Mr. and Mrs. Seller slash owner, in no way will post any negative comments about me or any comments concerning our relationship. And if you do, you're subject to penalty. That you could be at risk of losing your entire commission if you have an agreement like that. So just check. Our LIBOR form agreements don't have anything like that in them. But if you use any other type of agreements, just check, make sure that you don't have any clauses like that that could be putting yourself at risk. And the last kind of couple more minutes, the last two topics I do want to cover today is just some threats that are out there regarding cybersecurity and then lawful source of income discrimination. I've made a commitment to cover this in just about every class that I teach because it continues to be the number one area of undercover testing. And unfortunately, there have been members who and property owners who don't understand the law. New York State and also our local municipalities, lawful source of income is a protected class. It's very easy for undercover testers to test discrimination in this area, so that's why it is such a tested area. But I just cover this because it's really simple. Once you see this, it's really simple to understand what lawful source of income discrimination is, and also how to avoid it. So I I want to just cover housing providers can ask about income, right? They can ask you how much you make, where your income comes from. They could ask you documentation. That's fine. That's not what the law is concerned about. The law is concerned about treating all lawful sources of income equally. So a broker, a landlord can't say, I like one form of income, someone having a job, better than someone that gets their lawful income from another source. And that would include any of these other sources. So a landlord has to treat things like child support, alimony, foster care, social security, and housing choice voucher income the same as it would any other income. They can't say, I don't like voucher holders. That is discrimination. It's no different than saying, I don't like women. I don't like this race. I don't like this religion. It's discrimination. Just substitute Section 8 voucher holders for any other protected class. That is source of income discrimination. I mentioned there's been a lot of recent, just in the last couple of years, significant fines that have been levied against apartment complexes, real estate brokers for violating the source of income laws. And what does it look like? It's making any of these statements. So landlords can't say, I don't work with voucher holders. Brokers can't say, I don't know if my landlord does, or let me find out, or this apartment doesn't take vouchers. That is discrimination. It would be no different than saying, well, what race are you? I have to find out if my landlord will accept a tenant of that race. It's the same thing. It's no different. So just substitute voucher for any other protected class. That is discrimination. So what do you do to avoid? Don't turn away any prospects because they say they receive any kind of financial assistance. You're going to just follow the same steps for every single tenant or prospective tenant that contacts you, right? Where are you looking? How many bedrooms? What's your price range? Certainly, if somebody has a voucher that doesn't cover or can't cover a certain, apartment rent, that's different. And that's not source of income discrimination. But it's just putting a blanket restriction or saying I'm going
Hello.
to work with somebody. That
Hi.
source of income. Oh, we need to stay on mute, please. We're almost done, I promise. Um,
Okay, what time?
Thank you. You want to show voucher holders the same apartments you would any other prospective tenant. Work with the voucher programs. I mentioned at the very beginning, we did a webinar yesterday with the New York City Department of Social Services that went over the statewide city FEPS voucher program. It's a great program. They answered a lot of questions about source of income discrimination, how that program works. Specifically, just so you all know, that program actually provides a New York City program, but the cities actually provides vouchers for apartments outside of New York City. It's a great program. I can't cover, the 45-minute webinar in the last minute I have here, but please, free webinar will be up on our website probably later today with some other resources. I want you all to check it out. And just the last point here on vouchers is if you have a owner who says, I don't want to deal with whatever it is, vouchers, Social Security, you just simply say, I can't work with you then, period. And I won't work with you. That is your out. You never want to accept any unlawful instructions from any property owner whatsoever. You don't have to, and you should never do it, period. Simple as that. Um, I'm gonna have to end here. I will make sure that the slides go up because I do have a couple other things since we're at the hour, just on some risks, cybersecurity risks that you should all be aware of. I encourage all of you also to take a cybersecurity class if you can, because you may tell me, well, Patrick, I'm at a small brokerage. Small brokerages are just as big a target as the large brokerages. If not, they're probably even bigger, because a lot of these scammers feel that you don't have the security protocols out there that a bigger brokerage might. So you are at risk for a lot of the things that are out there. So please take cybersecurity seriously. And with that, if you could just answer the poll, the class is now finished. I thank you all for your attentiveness. Wish everyone